The bank notification arrived on a Tuesday afternoon while I was in a meeting. A deposit. $1,400. From a name I did not recognize. 2 words, a first and last name, neither of which corresponded to anyone I had done business with or expected money from. I looked at it for 3 seconds, made a note to check it later, and returned my attention to the meeting because the meeting was not finished. Later I sat at my desk and looked at the deposit properly. $1,400. Monthly amount. The name meant nothing to me. The memo line said, rent, October. I did not own any rental property. Or rather, I did own property. One apartment purchased 4 years earlier, in a building 30 minutes from where my husband's family lived. We had bought it as an investment, the plan being to rent it eventually when the time was right and we had found the right tenant through the right process. We had not rented it yet. We had discussed renting it. We had not taken any steps toward renting it. I use that word carefully. The apartment was mine, purchased in my name with money from my own savings account, a decision my husband had supported and that had been documented clearly in the property records. I put my phone face down on the desk. I picked it up again. I called my attorney. Before we continue, please subscribe to the channel and let us know in the comments where you are listening from. My name is Grace Kim. I am 32 years old. And what I found when my attorney pulled the lease the following morning, and what it told me about the decision my in-laws had made without telling me, is a story about what happens when people assume that a daughter-in-law's property is a family resource and discover too late that the documentation disagrees. My in-laws, my husband James's parents, Edward and Patricia, had always had strong opinions about the apartment. Not hostile opinions. That is important to say because this story is not about hostility. They had enthusiastic opinions, the kind that arrive wrapped in helpfulness and are difficult to object to because objecting to helpfulness feels ungrateful. From the month we purchased the apartment, Edward had suggestions. He knew a property management company. He had a cousin who worked in real estate. He had thoughts about pricing, about tenant screening, about the right moment to list. Patricia had thoughts about staging. She had an eye for these things, she said, and offered twice to help furnish the space in ways that would maximize rental appeal. Take them. I said we were still deciding on the timeline. I said when we were ready to move forward I would let them know. This happened 4 times over 2 years. The same cycle. Their suggestions, my thanks, my statement that we were still deciding, their acceptance followed by the same conversation 3 to 4 months later. What I had not fully understood during those 2 years of cycles was that Edward and Patricia had not been waiting for our timeline. They had been developing their own. My attorney's name was Sandra Lee. I had retained her 3 years earlier for an unrelated contract matter, and had kept her because she was thorough and direct and had the specific quality of being unsurprised by things that other people found surprising. I told her about the deposit. She asked for the property address, the purchase documents, and access to the apartment's utility accounts so she could check for any service changes. She called me back the following afternoon. The lease, she said, had been executed 6 weeks earlier. It was a 12-month agreement. Standard residential form, monthly rent of $1,400, tenant move-in date the first of the previous month. The landlord listed on the lease was not Edward or Patricia. It was me. My name. My contact information. My personal email address, which my in-laws had access to through a shared family account my husband had set up years ago. My signature. Not my actual signature. A typed representation of my name in the signature field. The kind that appears when someone completes a digital lease form and types rather than draws their signature. They executed a lease in your name, Sandra said, using your identifying information. Without your knowledge or consent. I sat with that for a moment. Is that? It's fraud, Sandra said simply. Executing a legal document in someone else's name without their authorization is fraud. The fact that you own the property doesn't change that. I told my husband that evening. I want to be honest about how that conversation went because it matters to the story. James and I have a good marriage. The kind built on communication that is genuine rather than performed, and on the specific trust that comes from years of being honest with each other even when honesty is inconvenient. He had not known. I was certain of that before I told him and more certain after. His response had the specific quality of someone receiving genuinely new information rather than someone managing the delivery of something they already knew. He was quiet for a long time after I showed him the lease. Then he said, "I'll call them." I said I appreciated that. I said Sandra would also be sending a letter and that I needed him to understand the letter was coming regardless of the family conversation, because the legal matter and the family matter were separate and both needed to be addressed. He said he understood. The family conversation happened first. James, Edward, and Patricia on a Sunday afternoon at their house, which I attended and in which I said very little because James handled it and handled it well, which I had trusted him to do and which he did. Edward's explanation was the one I had expected. He said they had been trying to help. He said the apartment was sitting empty and generating nothing. He said they had found a good tenant. A young professional, reliable, exactly what we would have wanted. He said they had intended to tell us once it was settled because they had not wanted to involve us in the logistics. James asked whose decision it had been to use my name on the lease. Edward said it had seemed the simplest approach since the property was in my name. James said, That is not how this works. Sandra's letter went out Monday morning. 12 pages. The lease, the fraudulent signature, the unauthorized use of my identifying information, the legal exposure Edward and Patricia had created for themselves, and a clear statement of what was required to resolve the matter. The existing lease needed to be properly executed with my actual authorization or terminated. The tenant needed to be informed of the situation, and all future decisions regarding the property required my express written consent. The letter also noted that the $1,400 deposit currently sitting in my account would be treated as rental income and managed accordingly, and that any further deposits received would be held pending resolution. Edward called James the evening the letter arrived. I was told it was a difficult call. Edward was not immediately receptive to the framing of what he had done, which I had anticipated. People who act from what they believe is helpfulness are often the last to understand why the person they were helping does not experience it that way. It took 2 conversations and a follow-up call from Sandra to Edward's own attorney before the matter was resolved clearly. The resolution. The lease was re-executed with my actual signature. I reviewed the tenant's application myself, spoke with her directly, and decided she was exactly who I would have chosen if I had been involved in the process, which was both satisfying and frustrating simultaneously. The utilities were transferred properly. The rent payments were rerouted to an account I controlled directly. Edward and Patricia received a clear written statement from Sandra outlining what they could and could not do with respect to the property going forward. Edward signed an acknowledgement. Patricia did not comment on this, which was her way of conceding. The tenant, a woman named Sophie, has been in the apartment for 8 months now. She pays on time, communicates clearly, and has mentioned twice that she would like to renew when the lease ends. I am inclined to let her. My in-laws have not offered suggestions about the apartment since the letter. This is a significant change in pattern and I have chosen not to draw attention to it. Sometimes the most productive thing is to let changed behavior be its own acknowledgement. James and I talk about the apartment sometimes, the way couples talk about shared investments. Practically, with the specific shorthand of people who have been through something together and have come out knowing each other better. He said once, a few months after it was resolved, that he was sorry it had happened. I said I was glad it had, in a certain way. Not for the difficulty, for the clarity. We both knew now what the apartment was and whose decisions governed it and what the process looked like when those decisions needed to be made. Some things are clearer after they have been tested. The apartment is one of them. My name is on the lease now. Properly with my actual signature on a document I reviewed and authorized and understood. The way it should have been from the beginning.